this entity which was transferred, which is CGP Investments, the Cayman Island company. So they had transferred the shares of CGP Investments. So the tax department said they looked at the due diligence report, and on that basis they concluded, they contended that this CGP Investment, this company was actually interposed in the last minute. The parties never intended to transfer the shares of this foreign company. They were actually contemplating a transfer at the Mauritius level, that is, Mauritius companies transferring the direct stake in the Indian company. But in the last minute, they decided to interpose this CGP Investments and do it from there. So then they said, obviously, why should we regard something like this? This last minute, because the parties themselves have pierced the corporate veil. So then the court looked at, when the court looked at the whole history, using this look at approach, they looked at the overall structure and the history. Now CGP Investments has been there since 1998, this Cayman Islands company. Now the reason why they actually transferred the shares of CGP Investments and not the share, not at the Mauritius level, was that CGP Investments, apart from the indirect shareholdings in the Mauritius companies which finally held the Indian companies, also had certain direct interest in an Indian company which held those call and put options. Then they said there's a definite business purpose over here. If the shares were transferred at the Mauritius level, then they would have just acquired that leg without acquiring the call and put options or the indirect interest in that. So it was intended that it was transferred at that the shares of CGP Investments were transferred, so that apart from this 49-55% odd stake through the Mauritius company, they could transfer that additional stake through the put and call options, which could happen only if they acquired the shares of CGP Investments. So again, a bona fide business purpose, and hence it could not be disregarded.
Very good. As you can see on slide 17, all that happened was a straightforward sale of the shareholding of foreign company. It was all a big hangama happened, but actually it was nothing else but straightforward sale, and then we got into this discussion. Anyway, what I would like to do at this point in time, of course, this also brings us to the subject of withholding tax obligation on non-residents. So, our law, in a sense, provides that, okay, when any payment is made to a non-resident, there should be withholding by the payer. Okay, and I think, let me refer it to Bijal, if you can give us some comments.
Thank you, Mr. Yeah, so under our Indian laws, we have a provision under section 195, which states that any payment which is made to a non-resident, which is chargeable to tax in India, it is the obligation of the payer to actually withhold the taxes before making such a payment. Now, in this particular section, as you would know, there are two characteristics which must be fulfilled before this particular section can be invoked. One is the fact that you must be making a payment to a non-resident, and the second, most important, is that it must be chargeable to tax in India. In the case of Vodafone, it was the case of the tax authorities that when Vodafone made the payment to Hutchison in Cayman Islands, this particular transaction should have impeded the withholding tax provisions before making such a payment, and therefore the tax authority said that you are a taxpayer in default, and we would now recover the taxes from Vodafone itself. Now, the fundamental principle when you look at any withholding tax provision and really the legislative history as to why a withholding tax provision has been introduced in a tax law is to basically assist the tax administration in collecting taxes. So it is very surely a machinery provision which should be invoked to basically help the revenue to collect the taxes. The second most important fundamental question is that can you actually expect a non-resident who is not really a citizen of your country or a person resident in your country to actually help your government to actually collect the taxes? The third, more important, is that even if at all a non-resident is made subject to withholding tax provisions, how are you ever going to really enforce such a provision? If at all a non-resident, in this particular case, yes, Vodafone had, through its subsidiaries, did have like an Indian operating company, assets in India, etc. But if at all you are looking at pure out and out sale of one, by one non-resident to another non-resident, and if at all this withholding tax provision was ever to be invoked, the question would arise as to even if at all it has not been withheld, how are you really going to enforce this by going to that particular country and seizing the assets? It is not really a question which, when the courts actually looked at this particular provision, the Supreme Court very clearly said that a non-resident cannot be made subject to a withholding tax provision because it is merely a machinery provision. And secondly, it went on to say that in any case, this particular transaction is not chargeable to tax, and hence the question of withholding taxes does not arise. Now, as I really see this judgment and this particular provision of the Supreme Court, where they have made a broad brush statement to say that withholding tax provisions cannot be impounded on a non-resident, and of course, in any case, it's not chargeable to tax in India. The question arises that if at all a non-resident, if at all there is a payment which is being made by a non-resident, and if at all this particular income is chargeable to tax in India, the case of the Supreme Court specifically says that it does not matter whether this particular income is chargeable to tax in India. A withholding tax provision cannot apply to a non-resident, full stop. So obviously it's gone a little beyond what is mentioned under Section 195, and it would be interesting to see how the tax authorities will actually react to this judgment. As I would see this judgment, it's a welcome move with respect to this withholding tax obligation, especially since ever since this assessment was being made on Vodafone, where they were slapped a demand of $2.5 billion in withholding taxes. In most negotiations, be it M&A negotiations, investment negotiations, the buyer would actually have long procrastinated negotiations as to whether there should be a withholding or not, irrespective of whether a particular transaction was chargeable to tax in India or not. And of course, this led to escrow arrangements, indemnities. There were cases where parties actually took out a tax insurance for the payments to be made to the tax officers, etc. And I guess this particular provision, this particular judgment will give a lot of comfort to foreign investors, where the non-residents will not have to actually withhold taxes for such payments. Moving on to the next page on page 19 of the presentation. And the question often has arisen as to whether the Mauritius route is yet a good route to invest into India. As most of you all would be knowing that Mauritius contributes to almost 44% of the foreign direct investment into India. And there cannot be a presumption drawn by either the Union of India or the tax department that they are unaware of the quantum, both the FDI and the foreign institutional investment, which is coming in from Mauritius, even though it is not really from domestic Mauritius investors, it is from global investors around the world. Now, the case before the court in the case of Vodafone with respect to the Mauritius route was that when the Cayman Island company shares were being transferred, the underlying assets of the Indian companies were being held by a number of Mauritius companies, and the counsel to Vodafone made a specific remark that in this particular case of Vodafone, it is the case where a Cayman company's shares are being sold. However, if you actually look at the transaction, it could have been a case where the Mauritius company would have sold the shares of the Indian company, and there was a pure case of Azadi Bachao Andolan, which is a case of the Supreme Court, which would have actually given blessings to such a structure, and there would not really have been such a litigation. The case of Azadi Bachao Andolan is a very simple case, and I think it's historical in one sense, because I think it's the one and the only case where the tax department and the taxpayers were actually on one side of the table, and they were, arguing against a public interest litigant, which essentially was, ex-commissioner of income tax, who had gone to the High Court, Delhi High Court, and later to the Supreme Court to essentially state that the India-Mauritius tax treaty, and in more particular a circular which was allowing a Mauritius tax resident to claim a capital gains tax exemption from the sale of Indian shares, such a provision should be struck down as being unconstitutional, wherein the tax authorities have gone beyond their powers and given such an exemption under the tax treaty. A very interesting point which we must note vis-a-vis the India-Mauritius tax treaty is, in most cases, when you're looking at a double taxation avoidance agreement, as the name suggests itself, it's an agreement to avoid double taxation of the same income. If we see the India-Mauritius tax treaty, it has very specifically in the preamble mentioned as one of its objectives to foster trade and investment between the countries. And of course, when you're looking at the investment amount which has come into India of 44% over the years, it is a very big amount which has come into India. And to that extent, in the case of Azadi Bacha Andolan, the Supreme Court very clearly stated that since it is a treaty obligation, international treaty obligations must be respected and honored in good faith. And in the absence of a limitation of benefits article in the tax treaty, which does not curtail or restrain a third-party resident to form a Mauritius company for making investments into India, the India-Mauritius tax treaty, the benefits under the India-Mauritius tax treaty must be allowed and given credence to. I think in the case of Vodafone and the Supreme Court judgment, when it has upheld the India-Mauritius tax treaty, a very interesting point which it has made a reference to is the memorandum of understanding, which has been entered into by India and Mauritius as early as the year 1999, which specifically has an understanding between the two countries that each country will refer to the other country wherever there is any transaction or any investment which is tainted either by a financial crime or by a fraud. So this is the promise which has been made between the two countries, and in the absence of any of these particular provisions being impounded, the tax treaty benefits should be allowed. It's an interesting comment which has been made by the Supreme Court by both the judges by all three judges, which specifically states that in the absence of a limitation of benefits article, the treaty benefits must be allowed, and if at all the courts want to, or if at all the tax authorities want to restrict such a benefit, then this must be made either by way of a renegotiation of the treaty, or you must introduce a limitation of benefits article in the treaty itself. It would be interesting to see whether any such talks of renegotiation, or if at all there would be any provisions which would be entered into either by way of treaty renegotiations or by enacting domestic legislation to deny the treaty benefits. One important point which the court has held is that generally under the Azadi Bacha Andolan case, it specified that if at all there is a tax residency certificate, that was conclusive evidence of the residency of the Mauritius company, and the tax authorities could not sit on judgment as to whether this tax residency certificate was given in a justified manner or not. Somewhere the Supreme Court has watered down this broad brush which was made which has been made, and stated that it is conclusive evidence so long as it is not a sham transaction or a self-cancelling transaction.
So I think, as you can see, that very interesting observations have been made, lot more clarity has been provided. It would be very interesting to see what kind of observations have been made by the Supreme Court. What you need really in these matters is kind of a conceptual clarity. Once you have conceptual clarity, you can do your structures better. And Supreme Court has made some interesting observations, such as it said, certainty is integral to rule of law. Certainty and stability form the basic foundation of any fiscal system. Tax policy certainty is crucial for taxpayers, including foreign investors, to make rational economic choices in the most efficient manner. Whatever you want to do it, but tell foreign person or Indian investor, then he can decide whether to do a particular act or not. Legal doctrines like limitation of benefits and look through are matters of policy. So if government wants to introduce provisions, you introduce. Okay. It is for the government of the day to have them incorporated in the treaties and in the laws so as to avoid conflicting views. Investors should know where they stand. That's very, very important, because if government does not write this limitation of benefits in the tax treaties or look through provisions, then you have to allow. You can't look through, you have to only look at. That's first. So certainty is the first principle. Second, offshore structures and tax havens and all those things are again many a times misconstrued and sometimes rightly construed or whatever it is. What does Supreme Court say? Many of the offshore companies use facilities of offshore financial centers situated in Mauritius, Cayman Island, etc. Many of these offshore holdings and arrangements are undertaken for sound commercial and legitimate tax planning reasons without any intent to conceal income or assets from the home country tax jurisdiction, and India has always encouraged such arrangements unless it is fraudulent or fictitious. So, there is nothing wrong in using this tax haven or tax neutral jurisdiction as you may put them, because unless you are hiding income or doing something under the carpet, it's a very, very different situation. Let us look at Mauritius, okay. Most of you would say, why Mauritius is only for avoiding tax on capital gains, and which is, but another interesting part, Mauritius and India also have bilateral investment protection treaty. Okay, so if I am an American investor, what happens? US and India do not have bilateral investment protection treaty. So government, we used to have one with organization called OPIC, Overseas Private Investment Corporation, a kind of an agreement in 1956. It lapsed and okay, currently it's again a new bilateral protection treaty is currently being discussed, but it is not there. Now what happens if you use Mauritius, then your investment in India is protected. Otherwise, the Indian government can nationalize, it can reduce, like call and put option recently that controversy arose, but they are diluting the investment. Investment is not only nationalization. So investment protection deals with nationalization, insurrection, war, all the situation if something goes wrong and government of India confiscates or dilutes the value of your investment, then Indian government has to pay compensation. And do not get me wrong, these are realistic situations. We often say India is very stable, very judicious, absolutely fine, and I am 101% always excited with this particular Vodafone judgment. But the fact remains that when it came to Dabhol, there was, contract was reneged, there were other issues arose, matter went to the arbitration, and ultimately matter got settled. Many of you may not know how this whole Dabhol matter got settled, but the fact is that there are other reasons why you may use. So Mauritius, one of the important business justification is that India, US do not have bilateral protection treaty. So you may use Mauritius, and in none of the bilateral investment protection treaty, there is limitation of benefit article anywhere in the world. Okay. Interestingly, some of you are interested, I am speaking tomorrow in New York at 6 o'clock in Harvard Club on the subject of arbitration, and between 4 and 6 o'clock I'm talking Vodafone. But and on that is tomorrow, that is 25th, 26th I'm speaking at Harvard Law School on bilateral investment protection in absence of treaty with the US. So how do you protect US investment in India when there is no protection treaty? So if some of you are interested, maybe there will be some similar calling in facility. I'll be delighted. I'm also speaking on the similar subject in California in the next 3-4 days. But leaving aside all those, this is for those who are interested on bilateral investment protection treaty itself has become a subject of specialization today. It is very important subject, particularly because you see, we had recently a case where some people were given mines in Congo and then they were suddenly taken back and given some that piece of land, and there is another case in other jurisdiction. So in Africa, this is very common. And now there are going to be more opportunities in Africa, to invest. It is growing. If you see Economist issues some months ago, Africa rising. Private equity investment was, of the global, it was hardly 0.40%. It has tripled or 4 times gone up last 1 year or so. And they say that it will go up to almost 14%. People have suddenly figured out. So bilateral investment protection treaty is also another reason why I used to use this jurisdiction. Finally, very interesting comment. The demand, the Supreme Court's words, the demand of nearly 12,000 crores by way of capital gains in this one single case would amount to imposing capital punishment. Okay? They are saying it's capital punishment for capital investment. People have invested money and you are punishing them. Okay? Since it lacks the authority of law, sir, you cannot collect a penny without authority of law. And therefore stands quashed. And I also concur with all other directions given in the judgment delivered by Lord Chief Justice. So they say that this kind of an act is equal to capital punishment, hanging somebody. Okay. Now look at, this is one case. How many people are hanged? So there is a massacre going on in India, right? If you say how many people have been forced to pay tax which they were not supposed to pay, and tax department has exacted the tax, imposed penalties, interest, and all those kind of things. So if you see the ratio of tax litigation, there is a massacre going on, right? Genocide going on, tax genocide or fiscal genocide, or we call fiscal terrorism going on. Of course, don't take me that seriously, and not everybody is like that in the tax department, let us admit that also. But on the whole, you can imagine what kind of chaos is going on. It does not appear in the surface. So both at the people level and at the level of government representing the financial condition of the country in the budget, I think it is very important we reconcile and harmonize somewhere, Even direct tax is going to come, we'll discuss something about it. But, I think we have to do something to bring back some sense, some order, some wisdom in the behavior both of the government and the taxpayers, of course. Because if government behaves unethically, government does illegal, taxpayers are going to rebound with double the force. I think that is what is, you set example. They are leaders. If you set that example, others are going to react. So I think it is very important that we bring some stringent accountability. In fact, we have recently published this book on direct taxes score, the representation that has been made to government. Some of you are interested. One thing we have said, what is corruption? Corruption equals monopoly plus discretion minus accountability. What is the accountability when you collect tax? Is there a penalty on anyone who does that? There is no penalty, right? Is there interest? What kind of interest you pay? 6%. On the other hand, taxpayer has to pay 12%. I think you have to bring out some balance, So money is equally important to both. So I think that let us now sit back, think properly. If Supreme Court has provided very good guidance that we must have certainty. Just to go back to Lord Macaulay's words, I think, and some of you may or may not know, Lord Macaulay drafted our Indian Penal Code almost 155 years, 154 years ago. How many amendments have been made in Indian Penal Code? Hardly 2 or 3 or 4. And they could conceptualize, visualize every kind of crime. Murder, rape, battery, assault, everything they could conceptualize. They took enough time. They took 5, 6, 7 years to think everything properly, then brought in a law. It has lasted us for 150 years. Indian Contract Act, Indian Evidence Act, Indian Contract Act 1872. Okay. How? Indian Partnership Act 32. Okay. You can see we don't today sit back. We want to bring everything in a hurry. Now Supreme Court has decided what is, of course, the fear. We do not know. There is some committee appointed. Now, what is the mindset? Who are the members of the committee? 10 people appointed. They should bring independent lawyers, accountants, policy scientists, behavioral scientists, psychologists, and people like that, legislative draftsmen in the committee to consider. Now, only thing the fear is that, okay, now Supreme Court has said that, okay, you should bring this if you want to do that. Now, problem is that if you sneak in some provisions in the budget, like GAAR, if you introduce GAAR provision in the budget, I personally think it would be highly unethical, immoral on the part of government, because when the committee is considering a particular provision, okay, select committee, the standing committee, parliamentary standing committee, to whom this report has also been given, If they are considering at that point of time, you cannot sneak in. So my personal feel is, I'm sure government is not going to be that unethical and immoral to bring those provisions while they are being seriously considered by a standing committee. And that is one, again, in the middle of all that, I still have some faith, some confidence in the government, some degree of, there are people in the right places who will see that things are not unreasonably done. So, and that is what is surviving a country. I think these are some of the comments. I can go on and on. I can give another 2 hour lecture. But I've been a little upfront and blunt a little bit. But this is what I think we have moved to the right direction. It's an exciting moment. I think let us take it forward in the positive manner. Use this judgment. Government has said, the Supreme Court has said, bring certainty. So every section must give more certainty and no subjectivity as much as possible. There may be very, very few cases. And this is what something I would think. And I think we can also open up to questions. I know we are running a little extra time. We have no problem on that. Those who are on the call, they were about over 400 people, I understood from the registration. But I know some people may not be, but those who can stay on will be most welcome. And now we can open up to questions. Most welcome.
Thank you very much, sir.
Yeah.
We will now begin the question and answer session. Anyone who wishes to ask a question may press star and 1 on their touchtone telephone. If you wish to remove yourself from the question queue, you may press star and 2. Participants are requested to use only handsets while asking a question. Anyone who has a question may press star and 1 at this time. We have the first question from the line of Harold Adrian from Adrian and Associates. Please go ahead.
Hi. A quick question. The DTC takes effect on April of this year, and I would suspect that all the transactions that have been put in place will continue to be governed by the recent Vodafone decision. The concern that a lot of the funds have is whether there'll be any retroactive effect of the new GAAR provisions. And my take on it is that the GAAR provisions, if they become in April this year, will not have retroactive effect. Can you elaborate a little bit on the new GAAR provisions that are coming into effect in April of this year and the Vodafone decision?
Very good question, and I think everybody is afraid of GAAR. I understand that. That's section 123, and I think that's the most dreaded section. And if I may quickly say, I believe that, first of all, I do not think DTC would come as of 1st of April 2012. I am also somewhat doubtful of the entire DTC coming into play at some point in time. The reason perhaps is, again, this is my field, I have no control over government, and in our Gujarati language, sometime I would translate it, say that monkeys and kings, you don't know what their behavior will be, you can never predict. Okay, and it is completely in lighter vein, so take it with a little pinch of, salt, and not take it, that I am trying to blame anybody. But I think, you do not know what they are going to do. Okay. One thing I would think, if they seriously take this judgment into account and talk about certainty, then the GAAR provision that has been introduced, I think it will have to be substantially refined. What has happened? Let me explain to you. This study that has been done, some of you may want to take a look at it. It compares different GAAR provisions of different countries and how unethical we are. What we have done, we took Canada, Australia, everything. I believe we took South African GAAR provisions. Whatever safeguards that were provided to taxpayers have been systematically cut off. What you have taken off is the portion that only allows revenue at discretion without accountability. Okay, therefore, the GAAR in the present form has to be objected, because you say there is not a single word on taxpayers' right. All rights with the bureaucrats, all rights with the tax office. We need to have statutorily incorporated taxpayers' rights. These are internationally recognized rights. And there is a chapter on taxpayers' right. One of the internationally recognized rights of a taxpayer is that no retroactivity. So you should not have retroactive provisions. Maybe sometimes as an exception, even what happened in India long ago, court said that yeah, you can have amendment because okay, once in a while it can happen. What has happened is that in a routine, casual, and with a lot of respect, I would say in an irresponsible manner, we have been bringing retroactive legislations. That practice has to stop. It is a self-governing issue. Yes, Parliament has a right to bring retroactive. There is no clue whether GAAR is going to be retroactive, how long, how they are going to be implementing. So, I think that will have to be really looked into. And anything?
On this point, if I could just add,
Yeah.
in section 123 of the draft form that the DTC is in right now, there are three main tests that have been laid down insofar as when the GAAR will apply. It is when a tax benefit, when the sole purpose of an arrangement is to extract a tax benefit, and that transaction or that structure lacks A, commercial substance, B, a business purpose, and C, bona fide reasons. That is the only time when, if one looks at it, of course, literally reading the words, that is the only time when the tax officers can invoke the GAAR. Of course, what was commercial substance, what is business purpose, what is a bona fide, was not clear before the Vodafone ruling. After the Vodafone ruling has come in, I think there is substantial light as to how we can construe these very broad words. And so I think the GAAR, what people have been fearing, has substantially already been watered down by this judgment. That is one view that could be taken.
Absolutely. Only thing is that presumption has been provided to say that everybody shall be deemed to have engaged in tax avoidance. Everybody would be deemed. I think how can you have that kind of a law? And they are talking substance. No, substance itself could be a subject matter of dispute. And as has been said, when you go into substance, you will just not put an end. What is substance itself? Like if it's a share transfer, substantially underlying all the assets are transferred. You'll go back, and so I believe it is creating a lot of problem. Just to give you one example, Mauritius. People say you should have substance in Mauritius. Now, my question is, you need substance in Mauritius or you need substance in Mauritius company? Because you are looking at company, you are not looking at country when you are investing, right? I am just giving one example. Now, for example, there is no employee, nobody in Mauritius company, but they have employee in Singapore. Do you say there is no substance? So again, questions will arise, but substance, once you go into substance, motive, they have said motive, you cannot go into motives and stuff like that because it will make life miserable for people. So I think this section on general anti-avoidance, though in theory looks very appealing, and because every time you want to impose a tax, you bring something, there is a logic. But how you bring in, that is very important. In Canada, you see, it has been brought in and so carefully implemented. We have no confidence that that will happen because there is no clarity and there are a number of provisions. We cannot go into that subject. But I believe GAAR would not come in this budget. Later on, it will have to be substantially revised. Okay. And number three, that this provision has given powers to the Commissioner of Income Tax to override any provision of the treaty. So, in a way, at a commissioner's level, he can ignore any treaty and do anything that he wants just because it is, his perception is that there is tax avoidance. Okay, or even now look at the very fact that you have the authority to negotiate or modify the treaty. Parliament is delegated to some extent, CBD is a very high level authority. But when you delegate it down, because you're changing, modifying the treaty, if you delegate it so much down, then it will violate the principle of constitution, and that is excessive delegation. On that ground, it may be held to be unconstitutional. So that is first thing. Of course, apart from that, to ignore the treaty itself is a violation of constitution.
Sure, we can take the next question.
Okay,
What we
I'm
could
sorry.
perhaps do is we could alternate the
I'm
questions on phone and for them physically.
Oh, I'm sorry, we went on a little long, but a lot of people are concerned on GAAR, so we went too much into the detail.
Just
Yeah.
As a layman, I would call myself layman because I am not a lawyer. And what our clients and our friends are discussing, they are perplexed by about two issues. Number one, the issue has been, the Supreme Court has basically laid that the department had no jurisdiction to tax Vodafone. Number two, Vodafone had no obligation to deduct tax under Section 195. These two issues were raised before the Supreme Court earlier. The Supreme Court sent it back. So, people ask questions, why those two questions could not have been settled at the first stage? Why this football? Number two, basically the Bombay High Court judges were also capable. There is nothing new before the Supreme Court. The same argument, same facts, everything same are placed before the Bombay High Court judges who are also well versed in the law. Is it a personal perception or opinion of three individuals which have just changed the whole scenario? Why did the Bombay High Court overlook all these set of arguments which were there before the Supreme Court? What is new before the Supreme Court?
Very good question. The short reply to that is, first of all, what has been done in the past. Okay, there are always reasons for that. And when it comes to High Court or other judges, why they took a view or what, the very process of appeals is meant to remedy something wrong. Everyone can make a mistake. As I say, companies are artificial entities. The courts also have human beings behind them. They decide. So sometimes some case may not have been fully understood. Some facts may have been misunderstood. Some other interpretation and honest difference of opinion could be there. But when experienced judges from High Court get elevated to the Supreme Court, then they apply their judgment, wisdom, and give a ruling. So I think that's whole and soul.
Sure.
I think
Just to
people
add to
are
that-
on the
Yeah,
call,
sorry.
and I think people may want to.
Yeah, just to
I'm
add-
sorry,
No,
Vijay may want to add on.
Just to add to that, I mean, if we see the Bombay High Court, ruling, in the same case, almost 2/3 of the ruling is concurring with the Supreme Court ruling to a great extent. I guess the approach which was adopted by the Supreme Court and the High Court were diametrically opposite, where the Supreme Court has gone into the look at approach, and you just look at what the transaction is. So you look at the form of the transaction, and as long as the substance is not a sham, you cannot just strike it down. While the Bombay High Court went through the look-through approach, where they looked at substance over form. So I think that was a major difference in both of the cases.
I think there's also your first question on in the first round, why did the Supreme Court
Did
dismiss it?
not decide the basic issue.
It was actually a technical issue, because the first time it went to the Supreme Court, there was only a show cause notice. There was no actual order of the tax department saying that we have jurisdiction to tax this. So just because on the basis of a show cause notice, they had tried to go on writ petition. So Supreme Court said this is premature. Tax department, you first decide, do you have jurisdiction? If you decide you do have Vodafone, you can go to the High Court and then come to the Supreme Court. So that's why in the first round, they did not really go into the facts and decide this.
Okay, so we can take the next question on the call before we come back to Sitesh's question.
Sure, ma'am. The next question is from the line of Saurav Shah from NV Broking. Please go ahead.
Hello. Yeah, my question is that there are a lot of observations on LOB and Section 195 in the judgment of Justice Radhakrishnan, which is a minority judgment, but to which Justice Kapadia has not commented upon. So can it be regarded that a minority concurring judgment is as good as a binding Supreme Court judgment? Because the majority judgment of Justice Kapadia has nowhere commented on the LOB clause, the Mauritius Treaty and Section 195 in that great of a detail as Justice Radhakrishnan has commented.
Thank you for your question. I think the important thing to note is that Justice Radhakrishnan's judgment does not conflict with the so-called majority judgment. So in a way, you have to look at both of them complementary. So although it is Justice Radhakrishnan may have covered certain extra points, it is still a binding decision of the Indian Supreme Court, and it is binding. So because the only issue arises if there is another judgment, which may be say a 3 or 4 judge or even a constitutional bench, whether that has taken a different view. So I don't think that is the case. So whatever Justice Radhakrishnan has said, in my view, would be binding.
Actually, these are more supportive, observations, because you must have felt that you would like to provide further clarity to the whole and strongly worded statements such as, this kind of activities that amount to capital punishment. To just give a message, because sometimes Supreme Court judgments are there and they are not taken that seriously. So sometimes judges also very strongly communicate what they want to communicate. So that must be the reason to give a certain.
Nishith Desai, regarding this look at and look through approach, the Supreme Court has gone on the look at approach, but does not Section 9(1), which provides for deemed income and also indirect source of income in India, does not Section 9(1) inherently provide look-through approach?
The difference over here, however, is that it says income accruing or arising, directly or indirectly, from the transfer of a capital asset situated in India. It does not say a direct or indirect transfer of a capital asset in India. So, what it says, a legal fiction only goes as far as the fiction is intended to go. You cannot extrapolate the fiction to say that, because the expression used is capital asset situate in India, and there is no direct or indirect mention in that respect at all. So it says, as far as it is first of all, Section 9 is a deeming fiction. That income does not accrue or arise in India in any case. Because it's a deeming fiction, and the taxing statute anyway has to be literally and strictly interpreted, but in a deeming fiction, that standard goes a level higher. If that answers the question.
Yeah,
Nishith has been waiting.
You can introduce yourself.
Yeah.
Thank you.
Just one question over here. Just 1 second.
Firstly, I'd like to apologize for going back to GAAR, because this is the hype in the market today after this decision, that the government may come out with a GAAR in this budget. But before coming out with GAAR, which has an overriding effect on all treaties, there will be a strong opposition from bilateral countries abroad with a retrospective effect. So this is a condition which is very peculiar to what happened in La Mesa, cited by the Vodafone Council in 2000. In 2002, Australia, what they did was they even violated the 6-month rule before coming out with a legislation to tax that. So that kind of approach, that kind of accountability is expected from the government before they come out with a provision similar to GAAR, which has a provision talking about purpose, which has to be a substantial purpose, not any insignificant purpose, which can be, I have a right to structure my transaction tax efficient. I want to plan my tax. Every individual has a right to tax. So, yeah, why not? Why not a company? And this is very important in this judgment which has come out, that a corporate wheel is appreciated of a company. It has not been taken off at the whims and fancies of the tax authorities. That's just a comment over
here. Yeah, thank you so much. Good comment. Yeah, more questions on phone? Or anyone?
We do have one more question, sir. From the line of Ravinath Pai from Ernst & Young. Please go ahead.
My question is already answered when Saurabh asked about the binding nature of Justice Radhakrishnan's decision.
Thank you.
Okay, welcome.
Yes.
Participants, if you wish to ask
we have a question over here.
Star and 1.
Yeah, we have one question over here.
as the question had already been put up regarding section 9 of the Income Tax Act, I would like to ask that when the Direct Taxes Code comes into effect, so the section 5 does include the word indirect transfer of a capital asset in India. So will that cover this particular, like the later judgments which follow after the Vodafone one when the code comes into effect?
Again, we'll have to interpret what do you mean by indirect. For example, you sell the shares. Would you consider indirect transfer? What is the meaning of indirect? There, I should be able to add a little more, but one way of saying is no, it's a separate class of assets. Okay, indirect means I am selling this directly. Now, indirectly, I appoint an agent. Okay, and agent undisclosed principal, and he goes and sells. Really, it's my asset. Okay, Benami transactions and stuff like that. So I do not, again, on the face of it, I to review as we go along and what actual language comes up. But still, there would be some argument to say that that indirect may also not perhaps cover. Of course, one will have to look at the whole legislation. And
just one comment on that. This indirect transfer, right? It was there in the first draft of the DTC, and because all of us opposed, in the second draft, they removed because it is so vague. What is indirect transfer? Will you look through the entire world and say that there was some transfer in India? It was so vague, they decided to remove that. But then they came up with an alternative, very disastrous proposal that if you transfer shares of a foreign company where 50% of its assets comprise of Indian assets held directly or indirectly.
Yeah.
So that's how they've tried to transfer these. I mean, they propose to tax these Vodafone type transactions. And this is again, there is a big issue with this because it's a blanket rule. You're not even looking at principles of tax avoidance. You have to say, in these circumstances, we can pierce the corporate veil. Only when that company is a sham can we say that there has been a transfer. So then it is like a statutory piercing of the corporate veil. So in fact, in this book, if you see these submissions we made to the standing committee, you explain exactly what are the issues in that proposal.
I think one of the things that would become very important with all these issues coming up now or later, I think the importance of advanced ruling will increase, and generally most of you know that advanced rulings are delivered by bench of chaired by the that's a preferred judge. Generally, they have done a good job because some of these issues would still need to be interpreted. Yeah.
See, Nishith Bhai, whether the Supreme Court ruling will also
Same thing.
Okay.
whether the Supreme Court decision in Vodafone will also protect a case like Aditi Birla Novo, because my doubt is in that case, so the shareholding was by the Mauritius company, all the rights and decisions powers were with the US holding company, and virtually I would say there was no business purpose test except to avoid tax in the case of Mauritius company, because you can't ignore the corporate structure when the seller himself ignores the corporate structure. The case, in my view, the case becomes very weak.
See, we can go and discuss separately, but I think this case would certainly help. Number one, when suppose parent company negotiates or otherwise, it happens all the time. It means it is acting as an agent. Actually, real owner is the Mauritius company. So, what has happened in the argument? There has been little flipping that has happened. They think that the real owner is the American company, and Mauritius is only namesake. Okay, resignation. Actually, Mauritius company does exist in law. It has been, if you apply Supreme Court test, it has been there for quite some time. It came along in the structure as it is. So there are a number of factors that are helpful to the cases here. So, there will be some tweaking of the arguments possibly happening. And but I believe that still is a good case.
In reality,
can we just one thing? If there are other people on the phone.
We do have one more question from the line of Hardik Shah from Biari Shah and Company. Please go ahead.
when we have observed that of late there have been court judgments of substance over form, and there have been contemporary decisions being taken even on international forums of substance over form. Can we say that this decision concludes that form over substance has to be considered?
Yes, and yes, absolutely. Except when the form is sham. I think that principle was there. It was misconstrued. I think it has been again applied correctly. So it is going to give tremendous relief to large number of taxpayers in India as well as overseas. Yeah.
I covered the tax case in the Bombay High Court as justice, so I don't remember the section per se. But if I'm not mistaken, Justice Chandrachud had put the onus of default or intent not being there, of an intent to evade tax on the part of Vodafone, on the principle that they did not seek an advance ruling or they did not seek a clarification wherever the law is ambiguous about them being liable to tax. So if you could just comment on that and why the Supreme Court superseded that, and even the principle that I've mentioned is right. Have I remembered or quoted it right?
Yeah, so essentially here, the Supreme Court, when they held that the entire structure is not a sham, they looked at the bona fides of the entire structure, they looked at the history. So essentially they concluded that this was definitely not a case of tax avoidance. So if it is not a case of tax avoidance, if the parties have not really tried to secure a tax gain which they are not entitled to, there should not be any question of them being considered as an assessee in default, or at least for the purpose of penalties and things like that. So it really should not arise, because the conclusion of the Supreme Court was in favor of the taxpayer.
But if I'm not mistaken, the onus, if there is a gray area or in terms of interpretation, the law requires you to check with the authorities or get an advance ruling.
No, advance ruling is essentially a right. Advance ruling is a facility to help the investors get certainty on the Indian tax implications of their transactions. So essentially it's a right. They can avail of it. They may not avail of it depending on the circumstances.
I guess more importantly, I do not think in the case of Vodafone, there was really ever a case of uncertainty, or there was really a case of a grey area. I mean, it was a very clear out and out, outright sale of an offshore company. And to that extent, there is no provision under the Indian tax laws which require a strict interpretation, which could essentially cover such a transaction.
And I think probably you mentioned that there was an obligation to get a certificate. That was actually one judgment in the case of Samsung that the Karnataka High Court had pronounced, which was stricken by the Supreme Court within months. So there is no obligation on a taxpayer to get a nil withholding certificate from the tax authorities or the advance ruling authorities as such.
Any other questions on the phone?
Currently, there are no further questions.
Okay.
So I think one of the experiences that I have, I just with you, is that sometimes the tax department goes, and does something excessively, then it ultimately rebounds, because you see the Vodafone case. Let us say just a hypothetical discussion. What High Court say that yes, when you transfer foreign company shares between two non-residents, there should be tax. But it appears there is some other consideration for other agreements of right, wrong, good or bad. Okay. They said, okay, your jurisdiction, please go and fairly apportion. Fairly apportion how much is overseas tax, how much is out of $11 billion. You just attribute something, and what did tax department do? It's a $1 for sale of shares, and everything else for, so they became victim of their own doing. If they would have said, Vodafone you pay, I'm not saying they will do it, but I'm saying they will say, okay, pay us $500 billion or something like that, and will let us compromise the case. Perhaps, again, I'm not saying I cannot talk anything. The situation could be different. It's only illustration, so don't get it. But in number of cases, department can settle the case and buy peace on both sides. But when you do extreme, you have this situation. Same thing happened in case of Morgan Stanley, which I argued this is early. when advance ruling happened, okay, the point was made that, okay, if there is a permanent establishment and if the fees are paid on an arm's length basis, no further attribution can be made, okay. And perhaps, and some way it was, settled, okay. If department would not have gone in appeal, they could have still discussed this issue with other. Now what happened? They went to Supreme Court. Supreme Court revalidated, yes. So now it has become law of the land. So for all other cases, it has been a boon because, there are different theories in the world. Some say that no, some other addition should be made to permanent establishment in addition to the price you pay, even though on arm's length basis. So sometimes it is good that government litigates and at least we get some finality. So I would not say that litigation is great. It's good for lawyers once in a while. But I think that's hopefully I think one thing I would in the end say that we are passing through a new era. We opened up our economy in 1991. Lots of situations which never existed before, whether it's in electronic commerce or whether in terms of, tax treaties or other kind of cases. We are all confronting, tax department and ourselves, we are all confronting with new age issues on which there are no precedents, there are no guidance. So a lot of imaginary situations are coming up, and I believe that over a period of next 3 to 5, 7 years still, or maybe 10 years, we'll continue to go through this kind of cases. Like, what is going to be the next biggest litigation out of Vodafone? Oh, this is a colorable transaction. And this is a sham transaction. I think that's the next phase that you will see. So you have to understand this concept. If you understand this concept, you can take a position. And basically, as I said, one can go for advance ruling. Maybe settle the matter there. So more clarity we'll have. Like that, one after the other issues will begin to settle down. What happened when Indian Income Tax Act came or early time, and Mr. Palkewal and other solvers were there, they challenged number of provisions for unconstitutional provisions. They got clarity on capital versus revenue receipts and stuff like that, on deductions and stuff like that. For 20, 30 years makes a generation. So 30 years, you continue to have those issues. Today you don't talk those issues, yeah, they are there, but they are not those kind of things. If you see, all those issues are settled. Okay? So I believe we are passing through that next phase of uncertainty. We opened up in 1991, and as I said, generation is about 30 years. So 91 to 2001, so we have completed 20 years, maybe 10 more years. Expect some unexpected. And with those words, I would conclude this webinar, and all our friends on the video elsewhere. So thank you very much for making it to this occasion and participating in this event. It's been overwhelming response, and we are delighted that people have taken so much interest from world over to understand what is going on in India. And of course, as I have said, what the politicians and the bureaucrats have not been able to do, that is to reinstill the investors' confidence in India, I think Supreme Court has done. So it is Supreme Court which has brought back the confidence in the country where politicians and bureaucrats have failed. I think to that extent we must say heads off, and of course 3 cheers or 4 cheers to Supreme Court. I think we are still in safe hands, and I think rule of law prevails. Of course, partly lawyers as well. But, but thank you so much, and with those, and always most welcome to this place. Thank you.